It's time for an updated video on how to kick renters out in the state of California. We're not advocating to do it. What we're doing is we're giving you this guide for renters and landlords to understand the proper way to terminate a tenancy with a 60-day notice. Based on the number of phone calls we get from renters and landlords, we find that most property managers and real estate agents do not understand the proper way to terminate a tenancy in the state of California. Hey there, Christian Walsh, real estate agent with Wire Associates. We have been helping renters and landlords understand their rights before things go wrong. And remember, we can't give tax or legal advice, but for the most honest and up-to-date real estate advice, subscribe to this channel. First big question is, can a renter be kicked out? First, let's discuss at fault versus no fault. And by fault, whose fault do we mean? We mean the renter's fault. So at fault would be the renter's doing something wrong. They stop paying rent, set up a meth lab. Those would be examples of where the renter is at fault and a 3-day notice would be given for those cases. No fault means the renter didn't do anything wrong. The landlord wants him out, and we're going to run through different reasons that can happen. That's more typically a 60-day notice. In some cases, it could be 30 or 90 or longer. For a no-fault termination, the renter must be month to month or on a periodic tenancy. They can't be under a lease. Can't say 6 months into a 12-month lease, I'm going to terminate this tenancy with a 60-day notice for a no-fault reason. Has to be a periodic tenancy. And the last thing to know before kicking out a renter for a no-fault reason is whether there's a local ordinance in place that restricts a renter being removed for a no-fault reason. Some areas have very strict regulations, more strict than the statewide AB 1482. So make sure you understand local regulations. And away we go, diving into the latest notice of termination of tenancy that the California Association of Realtors produced. This is based off of new regulations that are buried in SB 567. We've released other content, including one of our most popular videos ever that talks about the changes in terminating a tenancy. We're going to run through this notice right here. Doesn't have to be this notice, but this one definitely meets the legal requirements. So the front here is a cover page and it has some good warnings, and these are warnings we've given you as well. Make sure that you double check to see if there are local rent and eviction control ordinances in place that will go ahead and be more strict, and you'll need to follow those, not this one. And of course, you should be using an attorney to do this as a landlord to make sure it's done correctly. And this is specifically for termination of a tenancy on a no-fault reason. It's not related to being late in rent or material breach of the lease or doing something illegal. Those are different forms and different ways to terminate the tenancy there. So that's a cover page. You're not going to give that to the renter landlord. That just gives you some advice. Pretty easy and basic at the beginning. Got to have who it goes to, and you got to go ahead and have where the property is located. Then it starts to get complicated, and the first thing you're going to check is whether it is a property is covered by the TPA or not covered by the TPA. What is the TPA? That's the Tenant Protection Act of 2019 that went into effect in 2020, also known as AB 1482. And we've released a ton of content on it. So if the property is subject to the Tenant Protection Act, you're going to go ahead and check that, and you're going to go to 2. If it is not subject to the Tenant Protection Act, you click here, and then you go to paragraph 3. Can't click both. One, it's either subject to or exempt from Tenant Protection Act. Starting off with properties subject to or covered by the Tenant Protection Act special procedures, and you can only terminate a tenancy for very specific reasons. We're going to run through those right now. So if the renter has been in possession for a year or longer, it's going to be a 60-day notice. It can be longer. You can pick a date that's out in the future. If they've been there less than a year, then it'll be a 30-day notice. And then there's a specific 90-day notice we're going to talk about when we get to the next section. So there's 4 reasons to terminate a tenancy under the Tenant Protection Act, and we're going to move from the bottom up. So number 4 is owner intends to comply with a government order, court order to make it vacant. So it could be that the court decides that it's not habitable and they're going ahead and kick everybody out, or eminent domain would be another reason that it could be potentially a court order to have everybody kicked out. 3 is owner intends to demolish or substantially remodel the premises. There's a new form for that under SB 567. We're going to show you what is required for that. 2, owner intends to withdraw the premises from the rental market. 1 is family move-in. So it could be the owner, a spouse, domestic partner, parents, grandparents, children, grandchildren. Straight line, aunts and uncles, niece and nephew, not included for family move-in. And there's also another required disclosure form for this that we're going to run through. Under the Tenant Protection Act, when terminating a tenancy, there will be relocation assistance that's owed. Again, check your local area to see if you owe more than what's required under the Tenant Protection Act, and that is 1 month's rent. And it's required when terminating the tenancy that you let them know whether you're going to give them that money or you're going to waive the last month's rent. Next section, properties not subject to the Tenant Protection Act. So these are exempt. Most single-family homes and condos are exempt. An owner-occupied duplex could be exempt. And then buildings that are larger, 2 units or larger, but have their certificate of occupancy 15 years or more recent, those would be exempt from the Tenant Protection Act. And in that case, there's no reason that needs to be given. So you don't see a box here to check that says why the tenancy is being terminated. And you don't see anything about relocation assistance. When it's exempt, the property is exempt from both of those things. So it simply says here a 60-day, 30-day, or 90-day. So a 90-day notice to terminate tenancy would be required, for example, for Section 8, Government Agency Rental Housing Assistance Program. Now, D is a special situation, and we really don't talk about this one very often. In general, I recommend giving a minimum of a 60-day notice for renters who've been there longer than a year. This 30-day exception is a very specific one, and you can read through that and see if it applies in your case. One of the biggest mistakes that we find when people go ahead and create their own notice to terminate tenancy is they don't include this language right here related to state law permits former tenants to reclaim abandoned property. Doesn't even seem like it fits on there. Seems silly. Why is this on there? Well, it's required by code. That must be on the notice in order for it to be valid. If a landlord delivers a notice to terminate tenancy and this language is not on it, it is an invalid notice. And if the landlord moves forward with an unlawful detainer, they're going to lose when they get in front of the judge. So it's required that that's on the notice. Landlords, if you're interested in selling a renter-occupied property, make sure you reach out to a professional like us first to make sure it's done right. And renters, if a landlord says they want to sell, you can recommend us as that real estate agent, and we'll make sure your rights are fully respected. Next important section, in order for a notice to be valid, it has to be properly delivered. You can't text it, you can't email it. You have to follow this system here, and you're going to use this as a receipt once you deliver the notice. You're going to check which way you delivered it, A, B, C, or D. And you're required to attempt to do this in this order. The best way to do it is personal service. So knock on the door, hand it over to the actual tenant, one of the tenants named on the notice, and give it to them. Number 2, or B, would be substituted service. So if there's another individual who's at least 18 years old that answers the door, you can hand the notice to that person. Next would be posting and mailing. So you're going to go ahead and leave a copy hanging from the door or shove it in the door. Take a picture so you have proof that you did it, and then you're going to mail it. It could just be a first-class stamp. I recommend using registered mail, not certified because they have to sign for it. Registered gives you a tracking number, and you're able to go ahead and have proof it was delivered. And D, the last way to deliver the notice after you've tried these others would be to go ahead and mail it by certified or registered mail. Again, registered mail, they won't have to sign for it, but you've got proof it was delivered. If you mail it, you need to allow additional time. Moving into the new required forms for property subject to the Tenant Protection Act. If you're going to use family move-in, well, there's new requirements under the law. SB 567 went into place April 1st, 2024. We've done other videos, but what you have to do now, if you're going to use that as a just cause reason, you have to go ahead and tell the renter who the family member is and what the relationship is, and the renter can request proof of that person and that they're related to you. So this is new, a new requirement under SB 567 in the state of California for terminating a tenancy with family move-in. And if you're going to terminate a tenancy through a no-fault reason for a property subject to the Tenant Protection Act, and you're going to use substantial remodel or demolition, there's required language that must go to the tenant, and it's on this notice here. And there's a statutory statement that must be on there. If it is not on the notice or included as an addendum with this language on it is not valid. And it says that if the demolition or remodel doesn't happen, that a renter can move back into the property and pay the same rent they were paying before, plus their owner's going to have to pay for relocation costs as well. The landlord is going to have to tell the renter what substantial remodel is going to be happening. And remember, a substantial remodel means that the renter is going to be out for a minimum of 30 days and usually should require permits. And if it does require permits, the landlord's going to have to give those permits ahead of time with the notice, or it's an abatement of hazardous materials, lead-based paint, mold, or asbestos. Maybe permits aren't involved, in which case an invoice for that work needs to be given to the renter. And then the landlord has to let the renter know how long it's going to take. It better be longer than 30 days. So this is another important change due to SB 567 related to a substantial remodel. So make sure that if terminating a tenancy for that specific reason, that you as a landlord are giving this required disclosure and information. And one of the biggest questions we get when we do this video is, where do we get these forms? Well, a landlord can go ahead and reach out to a local real estate agent they know. I also recommend that a landlord joins a local apartment or landlord association. They will have their own version of these forms that will meet the statutory requirements. Let us know your tenancy termination questions below. Subscribe to our free weekly email newsletter so you never miss a landlord renter update. Oh, and the next thing you need to know as a landlord or renter is in this video right here. Thanks for tuning in. It's been Christian Walsh, real estate agent with Wire Associates, and we can't wait to hear from you.